Hello, I'm Barry Lerner, and I'm speaking on appeals and modifications. Really, to get to this point, you have already had your trial and the judge has issued a ruling or an opinion. That may be 6 months or 2 years after the claim is filed. The question is, then what? Well, if the claim is to the benefit of the client and no action is taken, that matter becomes final after a fixed period of time. However, during that time period, either the claimant and his attorney or the employer carrier and their attorney may file several procedural pleadings, either a motion for reconsideration or rehearing, or a formal appeal. A motion for reconsideration or rehearing is when either party believes that the judge may have not considered certain evidence, new law has come out, or internally the order does not seem consistent. In these situations, your attorney will consult with you and make a decision as to whether that mechanism is appropriate. Similarly, either side may appeal the order. Under defense-based acts, all appeals go to the Benefits Review Board, which is a specialized board that hears appeals of Longshore and Harbor Workers' Compensation Act. Again, you're saying, I have now waited 2 years to get this matter to the judge and get an opinion. How long is it going to take? And again, unfortunately, there is a delay from the time that the appeal is noticed until briefs are filed with the Benefits Review Board and the Benefits Review Board issues its decision. However, if benefits are awarded to a claimant in the order by the administrative law judge, under the law, the employer carrier must continue those payments during the pendency of the appeal. Because appeals are so specialized, and the nature of the appeal and what will be heard or determined by the Benefits Review Board is much narrower than what was heard by the judge, it's important for your attorney to speak with you immediately after the order to determine if, in fact, it's appropriate to file an appeal. Similarly, the employer carrier, as I stated before, has the right to file an appeal. Very often, they will do that to delay the claim or to put it in a posture for settlement. Because the time frames are strictly enforced, it is important to consult with an attorney to determine if an appeal is appropriate. Another mechanism, once an order becomes final, is that of modification. Modifications are discussed under Chapter 22 of the Act and essentially allow a change in the order if situations change. Most common reasons for a modification is if the claimant's job status changes. If he was unemployed and unable to work at the time of hearing and subsequently obtained employment, the employer carrier may and very often does seek modification so they do not have to pay the amount in the order. Additionally, if the claimant's medical condition changes, either party can request a modification. More specifically, just recently I had a case in which the client was seen by a new physician who suggested a new treatment protocol that his prior doctor never suggested. The insurance company denied that. A motion for modification was filed, and the judge determined that it was appropriate that the order be changed, allowing this new doctor to provide the medical care requested. Because appeals and modifications are very specific and, most importantly, have time frames and statute of limitation issues, it is important to consult with an attorney on these issues. If you want any further information, please feel free to contact us at injuredoverseas.com. Thank you.